Excerpt Family Code of the Philippines. What is Family Code? The Family Code of the Philippines, Executive Order Number 209, was signed into the law by the President Corazon Aquino on July 6, 1987. The basic law covering persons and family relations governs marriage, legal separations, property relations between spouses, and parental authority, among others. Title 9, Parental Authority. Chapter 1, General Provisions, Article 209, says that pursuant to the natural right and duty of parents over the person and property of their emancipated children, parental authority or responsibility shall include the caring for and rearing of such children for civic consciousness and efficiency and the development of their moral, mental, and physical character and well-being. Article 210, Parental authority and responsibility may not be renounced or transferred except in the cases authorized by law. Article 211, the father and the mother shall jointly exercise parental authority over the persons of their common children. In case of disagreement, the father's decision shall prevail. Unless there is a judicial order to the contrary, children shall always observe respect and reverence toward their parents and are obliged to obey them as long as the children are under parental authority. Article 212. In case of absence or death of either parent, the parent present shall continue exercising parental authority, and the remarriage of the surviving parent shall not affect the parental authority over the children, unless the court appoints another person to be the guardian of the person or property of the children. Article 213. In case of separation of the parents, parental authority shall be exercised by the parent designated by the court. The court shall take into account all relevant considerations, especially the choice of the child over 7 years of age, unless the parent chosen is unfit. No child under 7 years of age shall be separated from the mother unless the court finds compelling reasons to order otherwise. Article 214, it says that in case of death, absence, or unsuitability of parents, substitute parental authority shall be exercised by the surviving grandparent. In case of several survive, the one designated by the court, taking into account the same consideration mentioned in the preceding article, shall exercise the authority. Article 215. No descendant shall be compelled, in a criminal case, to testify against his parents and grandparents except when such testimony is indispensable in a crime against the descendant or by one parent against the other. Chapter 2, Substitute and Special Parental Authority, Article 216. In default of parents or a judicially appointed guardian, the following persons shall exercise substitute parental authority over the child in the order indicated: the surviving grandparent, as provided in Article 214, and the oldest brother or sister over 21 years of age unless unfit or disqualified. Article 217. In case of foundlings, abandoned, neglected, or abused children, and other children similarly situated, parental authority shall be entrusted in summary judicial proceedings to heads of children's homes, orphanage, and similar institutions duly accredited by the proper government agency. Article 218. The school, its administrators and teachers, or the individual, entity, or institution engaged in children care shall have special parental authority and responsibility over the minor child while under the supervision, instruction, or custody. Article 219. Those given the authority and responsibility under the preceding article shall be principally and solidarity liable for damage caused by the acts or omissions of the unemancipated minor. The parents or judicial guardians of the persons exercising substitute parental authority over said minor shall be subsidiary liable. Chapter 3, Effect of Parental Authority upon the Persons of the Children, Article 220. The parents and those exercising parental authority shall have with respect to their unemancipated children towards the following rights and duties. First is to keep them in their company, to support, educate, and instruct them by the right precept and good example, and to provide for their upbringing in keeping with their means. Secondly is to give them love and affection, advice and counsel, companionship, and understanding. Thirdly is to provide them with moral and spiritual guidance, inculcate in them honesty, integrity, self-discipline, self-reliance, industry, and thrift, stimulate their interest in civic affairs, and inspire in them compliance. Fourthly is to enhance, protect, preserve, and maintain their physical and mental health at all times. Fifth is to furnish them with good and wholesome educational materials, supervise their activities, recreation, and association with others to protect them from bad company and prevent them from acquiring habits detrimental to their health, studies, and morals. Sixth is to represent them in all matters affecting their interest. 7 is to demand from them respect and obedience, and 8 is to impose discipline on them as may be required under the circumstances. Lastly is to perform such other duties as are imposed by law upon parents and guardians. Article 221. Parents and other persons exercising parental authority shall be physically liable for the injuries and damages caused by the acts and omissions of their unemancipated children living in their company and under their parental authority, subject to the inappropriate defenses provided by law. Article 222. The courts may appoint a guardian of the child's property or a guardian ad litem when the best interest of the child so require. Article 223. The parents, or in their absence of incapacity, the individual, entity, or institution exercising parental authority may petition the proper court of the place where the child resides for an order providing for disciplinary measures over the child shall be entitled to the assistance of counsel, either of his choice or appointed by the court, and a summary hearing shall be conducted wherein the petitioner and the child shall be heard. Article 224. The measures referred to in the preceding article may include the commitment of the child for not more than 30 days and accredited by the proper government agency. The parent exercising parental authority shall not interfere with the care of the child whenever committed, but shall provide for his support. Upon proper petition or its own instance, the court may terminate the commitment of the child whenever just and proper. Chapter 4. Effect of parental authority upon the property of the children. Article 225. The father and the mother shall jointly exercise legal guardianship over the property of their emancipated common child without the necessity of court appointment. In case of disagreement, father's decision shall prevail unless there is a judicial order to the contrary, where the market value of the property or the annual income of the child exceeds 50,000. The parent concerned shall be required to furnish the bond in such amount as the court may determine, but not less than 10% centrum of the value of the property or annual income, to guarantee the performance of the obligations prescribed for general guardians. A verified petition for approval of the bond shall be filed in the proper court of the place where the child resides, or, if the child resides in a foreign country, in the proper court of the place where the property or any part thereof is situated. The ordinary rules on guardianship shall be merely suppletory except when the child is under substitute parental authority, or the guardian is a stranger, or a parent has remarried, in which case his ordinary rules on guardianship shall apply. Article 226. The property of the unemancipated child earned or acquired with his work or industry, or by onerous or gratuitous title, shall belong to the child in ownership and shall be devoted exclusively to otherwise. Article 227. If the parents entrust the management or administration of any of their properties to an unemancipated child, the net proceeds of such property shall belong to the owner. Chapter 5. Suspension or termination of parental authority. Article 228. Parental authority terminates permanently upon the death of the parents, upon the death of child, and upon the emancipation of the child. Article 229, unless subsequently revived by a final judgment, parental authority also terminates upon adoption of the child, upon appointment of a general guardian, upon judicial declaration of abandonment of the child in a case filed for this purpose, upon final judgment of a competent court divesting the party concerned of parental authority. Lastly, upon judicial declaration of absence or incapacity of the person exercising parental authority. Article 230, parental authority is suspended upon conviction of the parent, the person exercising the same of a crime which carries with it the penalty civil interdiction. Then the authority is automatically reinstated upon service of the penalty or upon pardon or amnesty of the offender. Article 231, the court in action filed for the purpose or in a related case may also suspend parental authority if the parent or the person exercising the same threats the child with excessive harshness or cruelty. Second, gives the child corrupting orders, counsel, or example. Third, compels the child to beg. Fourth, subjects the child or allows him to be subjected to acts of lasciviousness. Article 232, if the person exercising parental authority has subjected the child or allowed him to be subjected to sexual abuse, such person shall be permanently deprived by the court of such authority. Article 233, the person exercising substitute parental authority shall have the same authority over the person of the child as the parents. In no case shall the school administrator, teacher, or individual engaged in child care and exercising special parental authority inflict corporal punishment upon the child.